And we'll ask counsel in 126491, State of Kansas versus Robert Cameron Grant, to please come forward.
May it please the court, Robert Grant appears through counsel Jacob Nowak of the Appellate Defender Office. Chief Justice, may I please request 3 minutes of my time be reserved for rebuttal?
3 minutes is reserved. Thank you.
Thank you. Tuesday of this week marked 4 years that Robert Grant has been incarcerated for crimes that he, as an 18-year-old, could not commit as a matter of law. See, when our sexual exploitation of a child statute was first enacted, we didn't have modern smartphone technology, and so it wasn't aimed at criminalizing high school sweethearts sending each other pictures. It just so happened that that conduct fell under the prior version of the statute. So in 2016, our legislature addressed the rise in consensual teenage sexting, amended our sexual exploitation of a child statute, and enacted a pair of Romeo and Juliet teenage sexting statutes. Those statutes either render conduct legal or misdemeanors or felonies upon subsequent or aggravating factors. It starts with anyone under the age of 19 who possesses a photo of a child in the nude who is 16 or 17 years old. That is not unlawful conduct. And that can become a misdemeanor if the child is in between the ages of 12 and 15, or if the recipient transmits the photograph that was sent to them. General theme and intent of this is that the legislature intended to exempt teenagers 18 and below from felony prosecution for sexual exploitation of a child in all but the rarest of circumstances. The problem is, no one in Robert Grant's case knew about these exceptions. Not the prosecutors who charged him, not the judge who oversaw his case, and certainly not the defense attorney who advised an 18-year-old Robert to plead to 2 counts of felony attempted sexual exploitation of a child for him asking a 16-year-old girlfriend to send him videos of her breasts. That is an injustice. It's the type of injustice that happens when attorneys and judges don't read the statutes that are applicable to the case before them. And this court in State v. Dinkle recognized that when that injustice happens, we need to fix it. We reject the premise that a reasonable attorney could miss a statutory defense or a statutory provision. Instead, we say we recognize this will happen. Lawyers will miss things. Judges will miss things. But our litigants' lives should not suffer because of our oversight. Those are powerful words, but as long as we are normalizing the summary denial of post-conviction motions, they're just words. Because I promise you, Robert Grant has suffered, languishing in prison, waiting for this appeal to resolve. This is not simply a case where Robert slipped through the cracks and nobody noticed. This is a case where the lower court saw that Robert fell through the cracks, and instead of lifting him up, they attempted to pave over that crack with Robert still inside. It is an injustice that everyone back in 2021 missed this, but it is unconscionable that we are 4 years into Robert's prison sentence, and he still hasn't had the opportunity to even argue to withdraw his plea. So today we're asking this court to reverse the decision of the Court of Appeals and remand this case for a long overdue evidentiary hearing on Robert's motion. And one of the things that's particularly frustrating about this case is this should have been a really easy question for the district court. Robert alleged his counsel failed to provide him advice on an applicable statutory defense. State v. Dinkle pretty much controls the law on that. We have a fact question. We should have brought in the counsel to discuss that, to ask them, did you advise that? If not, why not? And then let the court rule on whether or not Robert should be given permission to withdraw his plea. But we didn't get that, either at the district court or the Court of Appeals. Instead, we got a very convoluted interpretation of these Romeo and Juliet statutes that practically renders them meaningless. Because if images of teenage breasts are not included within the teenage sexting statute, it is hard to imagine what specifically would be. In my petition, I detailed sort of the micro of every step of the Court of Appeals decision that I believe they erred in. We may not have time to get to all of that broadly, though. The problem they had is they lost sight of the intent of the legislature. When the legislature enacted these statutes, they did so with the intent to exempt teenagers from our child pornography statutes. That is what they intended to do. Instead, what we have from both the district court and the Court of Appeals is effectively an interpretation that turns this into prosecutorial discretion on whether or not which one of these crimes gets charged. But that's not the law we made. We used mandatory language. It might have been the law if we had just enacted these juvenile sexting statutes without amending sexual exploitation of a child. But we didn't. Opened up sexual exploitation of a child, except as provided in KSA 215610 and 215611. Sexual exploitation of a child is. That means we don't ever consider sexual exploitation of a child until we are positive if the conduct is outside of the four corners of our Romeo and Juliet statutes. And if we look in there, it's more mandatory language. It shall not be unlawful for a person who is less than 19 years of age to possess a visual depiction of a child in a state of nudity who is 16 years of age or older. That's what Robert's alleging. At worst, he transmitted it because our definition of transmission includes requesting for an image. That is the literal crime that he pled to in the complaint. He asked his girlfriend to send him videos of her nude breasts.
Is there anything in the complaint or in the factual basis of the plea that gives us an idea of the images beyond that description at all?
No, I don't.
In other words, are there any descriptions of the images themselves that would challenge your characterization of them?
No, I think the problem here is, well, there wasn't an evidentiary hearing for these to be admitted. So any description is going to be based on secondhand hearsay to begin with. And those are all going to be fact questions for the district court judge and a jury, even if they do. Regarding what the description would have to be, essentially, the only things, if we have the applicable age range, that could bring it into sexual exploitation of a child is 5 things. It have to be either sex, sodomy, sadomasochistic abuse, masturbation, or image of somebody under the age of 12. Anything else gets covered by the Romeo and Juliet statutes. And as far as whether or not these images constitute that needs to be resolved by the district court, who has an opportunity to see it, not the 2 Court of Appeals panel judges who've never seen these photos.
Right. But I was thinking one opportunity where that might have happened was at the plea when there's some discussion of the factual basis. But in my review of the record, it looked just very generic, high level, just an admission to the statutory, the specific statute.
My recollection was it was pretty bare bones, but even if it was something that could have arguably fallen into one of those categories, none of that changes the fact that his counsel had an obligation to know the applicable defenses, present that to Robert, and let Robert make a knowing decision on whether or not he wanted to plea or take his chances at trial knowing he had a viable defense.
Let me ask, just for purpose of clarification, let me get to my notes. What this is, this is at its core, a motion to withdraw plea based on ineffective assistance of counsel.
Correct.
Right. Okay. So what we're looking at then is not what he pled to, but the 18 counts that were in what I'm going to call the first amended complaint or whatever, not the one that has the attempt, the other one. Okay, there were 18. And so when we're evaluating counsel's performance, we look at that complaint and say, was the attorney, I don't know whether he or she, was the attorney deficient, provide deficient performance in investigating and then discussing with the defendant any kind of defenses or any kind, this is what we're talking about is that, right? Not the attempt.
Correct, yes.
Okay. And then when you read the order denying the motion to withdraw a plea, and for that matter, that I think the Court of Appeals majority opinion, they talk about sexually explicit conduct as defined in the first statute, which is 5510.
Right.
But there's a different definition, and that one includes photos, right? A naked.
5510 includes
Right,
photos.
right. But as you noted, you don't do 5510. The first thing you do is go to 5610 and 5611, which necessarily has a different definition
Yes.
of sexual that does not include,
Correct.
these naked photos or whatever. Is this where the district court and the Court of Appeals erred because they were using the wrong definition?
That is certainly where the district court erred, for sure, based on their ruling. They reviewed the sexually explicit conduct definition from 5510, and whereas the one that's applicable is going to be the one from 5611.
But 5611 says, as used in
Yes.
5610, I think it says, as used in this statute and in 5610.
Yes, it says in
Right.
both of those statutes,
Right.
yes.
Okay.
The Court of Appeals, I think, eventually gets there. They take a very long, winding road to get there, where their first error is they conflate the two exceptions, because of course our exceptions have exceptions, and include propensity within that. And then they erroneously interpret the propensity statute to say that it's just prurient interest. And then they take that out of the jury's hand and say that these photos that we've never seen have, we're going to declare they appeal to the prurient interest. And then after all of that, they say, well, so we can't ever decide whether or not photos on their own should get the Romeo and Juliet statute. So we're just going to defer to how it gets charged, which then does kind of bring us back to they're effectively reading the wrong definition.
Wrong definition.
Right. Because we cannot go to that definition until we're definitively outside of the scope of 5610 and 5611.
Can I try to simplify all that, at least in my own mind? I read the Court of Appeals decision, the nut of the decision comes on page 5 when the Court of Appeals, and I'm just highly summarizing here, in my reading at least, essentially says that obscene materials do not receive any protection under the Romeo and Juliet law.
Yes,
That's what they said, right?
right.
And that's why they concluded that your client had no available legal defenses.
Well, sort of, yes. I don't know how they got from this is an obscene material to then he has to be charged under sexual exploitation.
Well, that's what I wanted to ask about. Like, is it correct? Or give me your perspective on the statutes themselves with respect to this question. Does obscene material receive any Romeo and Juliet protection?
And before I do, Chief Justice, I see I'm out of time. May I leave to answer this question?
Yes, you may.
Thank you. Obscene material does not necessarily, no, I don't think it has protection underneath the Romeo and Juliet statute.
Why not?
Because they've accepted it. It says these statutes do not apply to sexually explicit conduct, or apply to a visual depiction engaged in sexually explicit conduct. That's your first exception. Or a visual depiction that constitutes obscenity as defined by 6401. The problem is, first, if it is obscenity, they have to be charged under the promoting obscenity statute, which is another misdemeanor. Robert would be fine with that comparatively. But the second problem is these don't fall under the definition of obscenity. We again have a codified definition of obscenity.
The courts historically, almost to the point of becoming a punchline,
Sure.
Struggle to define obscenity.
Well,
this is the perhaps ambiguity in this statutory scheme that the Court of Appeals obviously struggled with, and frankly, I am too, because it seems ludicrous to me
that you would craft a Romeo and Juliet exception and then say, but obscene materials receive no protection. Because the way the Court of Appeals wrote it, basically the only Romeo and Juliet protection is for baby pictures in a bathtub, essentially. And they even use that as an example.
Well, they're definitely wrong about that because below the age of 12, the Romeo and Juliet.
Okay,
exception-
but the point being that the materials has to be, I mean, essentially entirely non-sexual.
We'll get,
And the whole point of the Romeo and Juliet exception is
right.
to cover sexual materials.
I agree with you.
So help
broadly.
me understand how that works from your perspective.
You are correct. When we look at the obscenity, it's far narrower than I think what you're suggesting. The only thing we add, because again, it's got the four that we talked about earlier: sex, sodomy, sadomasochistic abuse, masturbation, excretory functions, and then lewd exhibition of genitals. That's codified. It has to be codified by Miller v. California. So breasts, the buttocks, those are never going to be able to be obscene or sexually explicit as a matter of law.
Well,
in
the Court of
situation.
Appeals relied on the definition of obscenity that the average person would find it appeals to the prurient interest.
Right. They used one of the three mandatory
And
elements.
wouldn't the average person find that these photographs
I
appeal
don't
to?
know. That's a jury question. I don't think most jurors would say that an image of a female breast is morbid enough to appeal to the prurient interests of in the way that,
Really?
yeah, I don't. I think I think that the average person
I'm
prurient
just
interest-
concerned, and I don't mean to camp out on that question.
No, it's fine.
But I'm concerned that the obscenity portion of this is it swallows the exception whole, or it swallows the Romeo and Juliet exception whole, which really is how I read the Court of Appeals opinion.
If there's, again, I'm gonna stand on all three of those prongs of those elements have to be met, both because there's a conjunctive and that's how we interpret it, and because Miller v. California tells us we need all three. So it can't just be prurient interest. It also has to be sex, sodomy, sadomasochistic abuse, masturbation, excretory functions, or lewd exhibition of the genitals. Breasts and buttocks are never going to be able to fall under promoting obscenity
Okay.
because they're not expressly
So
codified.
you would suggest the Court of Appeals may be erred as a matter of law by relying solely on the prurient interest?
Absolutely,
Okay.
yes. You need all three. And even there, if it were just prurient interest, that's a fact question for a jury.
Okay.
You know, and doesn't, I took the statute to be codifying the definition of obscenity in sort of the normal First Amendment category where there's a difference between pornography and obscenity. And so the statute's carving out the obscenity part, which is, you know, not pornography. I mean, am I misreading all this?
I mean, it's certainly carving out.
California, that's obscenity. It's not pornography.
Right. I suppose I don't know the difference between those two off the top of my head. I've always kind of interpreted obscenity
Well-
being the way we lawfully regulate pornography that is more obscene, so obscene that it would violate the First Amendment.
Right, but it has to be more graphic
Yes,
to make it into the obscenity category. And then there's this other category, and it'd
right.
be hard to
And I think,
define it, but it doesn't restrict you know, all depictions
Right.
of sexual activity is not obscene.
right. And I do think that's maybe where I got lost in my thought on while breasts wouldn't necessarily be
Right.
obscene. We see them in movies all the time, and it's not considered a crime to show those movies or anything of those lines. So I don't think contemporary community standards have demonized the image to the point where it can just be governed.
One last question. I started off by saying that this is a case about, basically a motion to withdraw a plea, and ineffective assistance of counsel. And given all the questions, and ambiguities and you know, if, you know, we don't even have to decide all that, do we? Just
No.
given all of that, you know, the question is, did counsel investigate any of this and talk to his client about it?
Given everything we've talked about today, it sure seems like there's a fact
Right.
question or two to ask.
Yes, thanks.
For all those reasons, we would ask this court to reverse and remand for an evidentiary hearing. Thank you.
Thank you.
Hey, please the court, Christy Allen, Assistant District Attorney, appears on behalf of the state of Kansas. And I would, for a moment, just like to take the focus back to what Justice Sandridge was talking about. This was a motion to withdraw plea post-sentencing. So we're looking at a manifest injustice standard. In order for a district court to grant a hearing, a summary disposition of a motion to withdraw plea is proper when the defendant's motion does not raise a substantial question of law or tribal issue of fact, and the files and records conclusively demonstrate the defendant is not entitled to relief. And what we have here is a district court. I know there's been discussion of obscenity, but we don't even have to get to obscenity because the Romeo and Juliet statutes themselves say sexually explicit conduct or obscenity.
Can I back up before we even start to talk about the statute?
Mhm.
Is it true that neither counsel nor the court knew about the Romeo and Juliet defenses in this case?
From preparing for this oral argument, I can tell you that that is not correct. It is not correct that they did not know of the statute. And that leads me to the part of my argument where Romeo and Juliet statutes are not a defense. That's not something you go into court. If you're charged with sexually explicit conduct or sexual exploitation of a child, that is not something you go into court and you say, Judge, we're going to raise this defense. We would like jury instructions that reflect our defense. If you're charged with sexual exploitation of a child, there is a sufficiency element to that where if the state does not prove sexually explicit conduct, then you're acquitted. You're not acquitted because you're 18 years old and you possess a picture of a female breast.
Well, let's just call it a carve out then to the sexually explicit,
Okay.
to the crime itself.
Mhm. Okay. But that's still,
I mean, it seems as though nobody thought about this.
and I don't think that's accurate. And speaking with the prosecutor who charged and was ultimately going to take this to trial. And when we talk about this, we keep talking about nude images of a female breast. That's not necessarily the evidence that would have been presented at trial. Granted, we don't know what those images are because they are not in the record. And my
We
understanding,
do know what they are because in the affidavit, whoever wrote the affidavit described each of the 18 pictures.
it described pictures, but what we also have is in his motion to withdraw plea, we have the defendant telling the district court that he has a video of them having sexual intercourse. And sexual intercourse falls within that definition, both definitions of sexually explicit conduct. So when you have the district court judge read that motion to withdraw plea, and he starts with, I have a film of the underage victim and myself having sexual intercourse, I think we get past the images of the female.
That wasn't part of the charging documents, right?
There was nothing specific in the charging documents. That is correct.
In each of the 18 counts, there was no charge for that.
There was nothing specific in the charging.
And for that matter, they used the language of the statute, but in the affidavit, there's nothing about him transferring or promoting or even receiving. It's all about what they found on his phone, which would be possessing, correct?
I think where I would disagree with you respectfully, Your Honor, is the fact that promoting a performance can be enticing someone. Promoting is defined in the statute.
Where was it in the affidavit that he enticed? Nowhere. I've read it twice.
Right, but my understanding is this probable cause, this charging affidavit just sets out the basic images. And so if we were to have a preliminary hearing, then you call in witnesses. It's the only evidence in the case is not just in that charging affidavit. That charging affidavit is what gets your foot in the door to be able to get a charge before the court.
But we don't know that, I mean, you're trying to tell us what would have happened if they'd have had a hearing, I feel. Let's start with the lens we have to analyze whether as a matter of law defense counsel had an obligation to talk to this kid is based upon the original charges. That's the duty so what we have to do is figure out whether the Romeo and Juliet statutes applied
Or could,
to what was in the original complaint.
Correct. And because that original complaint alleged possession of sexually explicit conduct and promoting the performance of sexually explicit conduct, then the Romeo and Juliet statutes do not apply.
I'm not following what you're saying, because the very first thing in this statute says subject to 56, 10, and 11.
It says except as found in, yes,
Right.
yes.
So
And-
don't you, I mean, necessarily when you're charging under that statute,
Mhm.
maybe you don't say it as a defense, but as Justice Stiegel said, it's a carve out. So you have to go first for the state, even improving their case first, has to go to 56, 10, and 11, don't they?
They do. And so there's something more there. There's something more there that caused the charge to be sexual exploitation of a child. When we talk about this, when you talk about the charging affidavit, it's not just female.
Talking
threat.
about sufficiency of the evidence. Going back to, as Justice Biles just said, given that, did defense counsel have an obligation to talk to this kid? Was there a duty?
So my response to that, Your Honor, would be that defense counsel had the discovery, knew in theory, what all of the evidence would be, had the interviews with the victim, had the interviews with the defendant. It was more than what was just reduced to that charging affidavit. And so if what he knew was that the Romeo and Juliet statutes do not apply because it's not
Isn't
just.
that a fact question for the judge to decide at an evidentiary hearing on a motion to withdraw?
It could be. It could be.
So you're agreeing that we should remand it for that purpose?
I understand that given the complexity of these statutes, that there would be a desire to remand. My best argument for why no remand is necessary is because the statutes themselves say that that they do not apply to sexually explicit.
But sexually explicit conduct, you're first supposed to go to 56, 10, and 11. And sexually explicit conduct defined there is different than defined in the original statute.
Correct. It leaves out exhibition in the nude. It leaves out lewd exhibition of genitals, female breasts, or
Right.
the pubic area of any person. But what I'm saying is when we're here to review the district court's ruling on the motion to withdraw plea,
And he used the definition.
because the charge was under 55K, he used the definition of sexually explicit conduct in 5510.
He ignored the whole beginning of the statute that says
Because-
except as provided.
Because he was told by the defendant in his opening paragraph, there is a film of me having sexual intercourse with an underage child. But
But it doesn't say that in his order.
it does not say that in his order, but if we're looking at the motion and the records in this case, the motion in this case begins with, we had sexual intercourse. There's a film of us having sexual intercourse. So as the district court judge, he reads that motion in his mind is a film of them having sexual intercourse, and that fits both definitions of sexually explicit conduct.
But again, isn't the problem there that that's just not really what the state charged him with?
Right.
When you say not what the state charged him with, they charge him with possession, and with promoting
based
a
on
performance.
that whatever comment the defendant made was not the factual basis for the charges in the charging document.
I would concede that it was not the factual basis for the charging document, but that does not mean that would not have been part of the evidence
Right.
had they gone to trial. But the defendant himself removed this from trial and by entering this plea. And so I guess my point is when we're looking at the performance of counsel, we want to say that there's no way that this counsel could have looked at these two statutes and not told him about that. But what we don't know is what information that counsel looked at, and perhaps he also knew that the defendant had this film. And so in counsel's mind, I don't have to tell him about this because this is sexually explicit content.
But isn't that the reason
Document
why?
here that it needs to go to an evidentiary hearing. I mean, this is the argument the other side should be making, that it would need to go to an evidentiary hearing so we could find out what was in counsel's mind.
But
There's a factual dispute.
in that plea, in the plea itself, defendant tells us that it's sexually explicit conduct. He states that it's sexually explicit conduct. I understand you may not like
Under
that answer.
5610, which includes a naked picture. And that's what he repeats over and over and over.
I don't-
in his,
I don't know that 5610 includes a naked picture.
the definition of sexually explicit conduct, it does.
Sexually
You just
explicit,
said that.
except, so are you talking about exhibition in the nude? That's your reference to a
Yeah.
naked picture? But that can also be more than just a naked picture. And what we have from the charging affidavit is it's more than just a naked picture.
Really? Because I connected all 18 of those pictures where he
You-
says, I reviewed image, whatever, to the charging documents, with the dates. And I didn't see anything more than a naked picture.
A 15-second video file where the defendant is lying on top of the juvenile between her legs with a blanket partially over them. Both the victim and the defendant's faces are visible as the camera moves up and the defendant is kissing the victim between her exposed breasts. That's not just a nude
That's not
photograph.
sexual intercourse.
That, I didn't say that it was, Your Honor. That was, I'm not saying that that is sexual intercourse.
Well,
You
what does it
also-
fit under the definition of sexually explicit conduct? Actual or simulated sexual intercourse or sodomy, including genital to genital, oral to genital, anal to genital, oral to anal, whether between the same or opposite sex, masturbation, and sadomasochistic abuse. Which one does that fall under? That video.
That video does not fall under that definition.
Bingo.
But there's more than just when you talk about nude image, this is more than just a nude image. There's action in this image. So it's not that it fits within sexual intercourse, but when we get to, he was charged under promoting a performance. Okay, so this is promoting a performance that we can deem sexually explicit conduct.
Where's the promotion?
He tells us that there was promotion. The
It's not
defendant,
in the charging document. We're not talking about what he pled to or his motion to withdraw a plea. We're talking about before any of that happened. Did his counsel advise him based on the 18 count information / complaint? He didn't tell us any of that.
counsel didn't tell us any of that.
No, you're saying that the defendant himself told.
No, I'm saying that if we're reviewing the district court's order denying the motion, part of that motion is the defendant's statements that he has a film. So as the district court judge is
You're
reviewing
making that. That's pure speculation. I mean, when you read the order denying, he doesn't say all that.
It's not pure so you're saying that I'm assuming that the district court judge
Relied
Read-
on that particular comment in the motion. He doesn't say that.
I apologize. I guess I assumed that when a district court judge reviewed a motion that they took the information within that motion and analyzed the information provided in that motion.
Even if the district court did, even if the district court said explicitly, you told me this, I'm relying on, I mean, that's error, right? Because that alleged video was not part of the charge that he pled guilty to. It has nothing to do with his motion to withdraw his plea. It might be something you could charge separately, but I just don't see any relevance to that.
So just so I understand, you don't see relevance of the defendant admitting to having more than what was in the charging document.
Because he's making, his motion is, I want to change my plea to what you charged me with. And what you charged this defendant with had nothing to do with that alleged video.
In the charging affidavit, in the affidavit of probable cause, my understanding is the state is not limited to the information in the affidavit of probable cause and presenting evidence at trial.
I think the focus in, keep wanting to get back to the original charges. And I think we would all agree that a defense counsel has a duty to talk to the client about whether the charges that are alleged apply to the defendant, right?
Yes.
And he's coming in and saying, my lawyer didn't tell me that these charges might not apply to me. So that's, again, you're nodding your head. So, okay, so we all agree that much is there.
That he's claiming that his counsel did not talk to him.
I understand he's, you're not
Yeah.
agreeing. I know you're not
Yes.
agreeing. I'm just saying that's the claim here.
Yes.
And so how does the district court ignore that for purposes of a summary denial of this motion? Nobody's saying, you don't have really good arguments once you get everybody in a courtroom. The question is, how do you get to a summary denial based when the client says, the defendant says, I wasn't advised that some of these charges might not apply. And we know as a matter of law, some of them might not apply just based on looking at that and looking at the circumstance. But what else does the district court get to look at to do a summary denial of this application?
My understanding is that when the district court looked at the motion, he saw that he pled to, and I understand.
Doesn't matter how does it matter what he pled to?
I understand. I'm just trying to tell you what was in the order of the district court. The district court reads this and says you pled to promoting or attempting to promote the performance of sexually explicit conduct. Sexually explicit conduct is not covered by the Romeo and Juliet
But
statute.
what does that have to do with the allegation that the defendant hadn't been properly advised about what and I would call it a defense when you would want to say these charges don't apply to my guy. That's a defense. And here the defendant saying, I wasn't told that these things might not apply to me. And so then I copped a plea thinking that I was sunk on 18 charges. That seems to me to be the essence of what's here. So how does the district court get to summarily dismiss that notion?
I apologize if I seem to be
I'm just saying,
contrary.
So if the district court said, I can dismiss all this because I see what you pled to, then it seems to me it's a fair argument for them to say that doesn't apply to what our motion was. And we can evaluate that.
So the district court said that as a matter of law, because the statutes themselves say it does not apply to sexually explicit.
What you pled to.
That is what the district court said, but the district court can be right for the wrong reasons. And so the district court, looking at the charging document, if he's reviewing the motions and files of the case, which is what he's supposed to do, he can look at what he was charged with. You were charged with sexually explicit conduct. And because you were charged with sexually explicit conduct, the Romeo and Juliet statutes themselves say that they are not available to you.
But I thought you agreed with me. The defense counsel would have a duty to tell this defendant that some of these allegations don't apply to you. As opposed to, there might be some where you get tagged, but there are also some that you might not apply. It seems like that the defense counsel has an obligation to have that discussion with the defendant.
I agree.
Right?
I agree that defense counsel has an obligation to discuss possible defense.
The whole range of what's here.
Correct.
Not just, well, they allege this over here along with 12 other things that don't apply to you, but they did this one. So now there's no duty to advise the client properly. That's where I'm struggling with this.
And my response to that would be the defense counsel also was aware that sexually explicit conduct is excluded by the Romeo and Juliet statute.
How do we know that?
Doesn't the defense counsel have to say that in a hearing? That's all we're getting at here. This is a summary dismissal.
I
So
understand.
We've got a limited universe that we get to look at here.
I understand.
So I'm saying what's within the limited universe? How do we sustain or affirm what the district court did here?
Again, my best argument is just he saw that it was sexually explicit conduct, and as a matter of law, sexually explicit conduct does not apply to the Romeo and Juliet statutes.
So that, yeah, so your argument is essentially, even if there's deficient performance, it's not prejudicial.
Correct.
Isn't that circular? I mean, if you're trying to withdraw your plea, you're saying, I'm not guilty of the crime as charged. It seems to me your argument is the district court looked at what he pled to and said, well, if you're guilty of this, then you don't have a defense under Romeo and Juliet. That's entirely circular. The whole point of the defendant's motion is he's saying, I'm not guilty of this.
And the defendant's motion itself says I'm not guilty because I was under 19 and possessed a nude photograph of my 16-year-old. That's what his pro se motion says. His pro se motion requested the dismissal of all charges.
But doesn't it have to be an error of law for a district court judge to deny a motion to withdraw a plea by looking at the charge that was pled to and saying that since you pled to this, you don't have any available defenses? I mean, that's the whole point. He agrees with that. That's why he wants to withdraw his plea.
And I understand, and I agree that the district court's order does reflect the charges that he pled to. But again, a district court can be right for the wrong reason. And if the district court reviewing the charging document sees that it is sexually explicit conduct and reads that there is not sexually explicit conduct does not apply, if there is sexually explicit conduct, then the Romeo and Juliet statutes do not apply. The district court is looking at that, then he concludes.
What factual basis would he have to make that conclusion, draw that conclusion? What possible factual basis could there be?
What possible factual basis for him to conclude that he was charged with sexually explicit conduct?
Maybe we're talking past each other.
I
but
apologize.
Your argument appears to me to be that the district court relied on the charge that he pled to.
And that is what the order states. That is what the order states. Yes.
And I'm struggling to see how that's not an error of law.
Because again, he can be right for the wrong reason.
What's the alternative reason? Maybe that's what I'm struggling with.
That he was charged. So when we talk about the legislative history and counsel submitted legislative testimony, and in that legislative testimony, it even points out that these statutes are meant as a tool for prosecutors and law enforcement. And so this is a situation where prosecutors and law enforcement review this material. This material is reviewed and charging decisions are made. Charging decisions are made based on the evidence that the state thinks that it can prove at trial. And the state charged more than something that the Romeo and Juliet statute would cover.
What?
I
mean, all they did was say sexually explicit conduct.
And I understand that. And we have the charging affidavit. We don't have the interviews of the victim. We don't have any of that other information. I don't disagree with you. I don't disagree with you on
You're basically just saying trust the state. I mean, that's what it sounds like.
I'm saying that.
So here's how it appears to me. Just try to be bottom line. You've got a charge of sexual exploitation. You've got an 18-year-old defendant, 16-year-old victim. These are very serious charges. This defendant has been in prison for 4 years. I just struggle to understand I don't even understand why the state, frankly, is defending this case, just to be blunt. How can it be that the Romeo and Juliet statute is never discussed in such a case?
At what point would it have been discussed?
Well, to begin with, between the defense counsel and his client.
And this goes into, this would have been a reason for an evidentiary hearing because we don't know. We don't know that that conversation
Okay.
doesn't happen. You are correct. But the reason that I am here today to pitch to you that it is unneeded is because the language of the statute says that these do not apply to sexually explicit conduct. And what we have was charges of sexually explicit conduct, admitted conduct in the plea that it was sexually explicit conduct. Therefore, the district court reviewed that, found that as a matter of law, since sexually explicit conduct does not apply to the Romeo and Juliet statutes, no evidentiary hearing was necessary. I see that I'm way out of time, and thank you for allowing me to answer your questions. If there are no further questions, we would ask that this court affirm the district court.
Thank you.
Chief Justice, I'm happy to answer any outstanding questions, but would otherwise waive my role.
I've got one. I was thinking about my questions to the state and wondering if I wasn't limiting the universe that the district court had to look at. Okay?
Okay.
So for purposes of the allegation, which is whether the defense counsel talked fully about the original charges, the district court also gets to look at the record of the case, right?
Correct, yeah.
And doesn't that inform, or why, I guess the question to you is, why doesn't that provide additional information within our universe that's being evaluated by the district court? Like, why doesn't that give enough information to be able to summarily deny and say there's no point to this business, which is kind of what summary dismissal is?
Well, in this scenario, I don't see what information within the entire record below would raise to that level. You would have to have, at a baseline, just concrete evidence that he fell outside of the Romeo and Juliet statutes. But even with that, I don't think that absolves the defense attorney's obligation to talk about those defenses with Robert and let Robert make the decision on whether or not he wants to risk trial on the 18 counts or whatever it was while presenting that defense, or take this plea to the 2 counts that he ultimately pled. And it keeps coming back to, there is a fact question about what Robert and his counsel discussed. For our purposes, we have to, since it was a summary denial, we have to assume that Robert is accurate in his assertion that his counsel never discussed these defenses with him. And we need to send that back down for that. I don't think there's anything in this record. Maybe if you have something specific that you want me to address, I can, but I don't think there's anything in this record that would take us out of that.
But you agree that our universe would include the court record?
Yeah, I agree.
In front of the district court as well. I mean, I was kind of narrowing it down maybe unfairly with the state when I was talking about just the original charges. There's a little more to it, I guess.
I do.
What I'm struggling with.
I will put in one caveat, though. The court can't credit assertions in the record. Like, so for instance, the affidavit, it's included there. The state hasn't met their burden to prove what's in that affidavit yet. So I don't think for the purposes of summary denial, the court can just assume that everything in that affidavit is true.
Well, if there were a factual basis for the plea and that factual basis demonstrated images that fell within the definition of sexually explicit conduct, is it fair to say that if that were the case, that any deficient performance was not prejudicial?
I don't think so. And my problem with that is a lot of times people will end up pleading to things that are legal fictions to get the benefit of the bargain. So I don't ever trust a factual basis to be concrete 100% what happened. It's just what the parties are agreeing to move forward. And if you don't have an attorney who,
Well, okay, let's just say, I just assume there is a concrete factual basis. They'd go through the images and make specific findings, and it's clear they fall within the definition of sexually explicit conduct.
say the images were in the record
Yes.
for us to look at.
Yes, yeah, absolutely.
Then yeah, I think maybe the state could have an argument that there wouldn't be prejudice
It's just your position is that's not what happened here.
That's not what happened here, and I could see an argument that that's still a fact question for the district court.
I'm curious about your response to your client's in his motion to withdraw the plea, as counsel pointed out, where he acknowledges that his phone was used to record himself and the victim having sexual intercourse.
And to be clear, we're talking that the victim recorded them doing that on the phone, right? Isn't that what it says?
It is.
It is, yeah. But what about that acknowledgement that there's that transmission of sexual intercourse?
I think it's a red herring in this case for a few reasons. One, wasn't charged. There's no evidence. We don't have.
I understand all that, but if I'm a district court judge and I'm looking at this and I see that,
Okay.
it completely takes it outside of the Romeo and Juliet exception or law. Do you just ignore that and say, what do you do?
You can ignore that, yes, because it's not going to be that statement, and nothing that Robert says at his eventual evidentiary hearing on this is going to be able to be admitted against him at trial pursuant to the doctrine of unconstitutional conditions, because he is asserting his Sixth Amendment right to effective assistance of counsel. Additionally, you can ignore it in large part because even if it's true, even if the state has one video, Robert pled to 2 counts. There's still prejudice from him not getting discussed this, because at worst, he's guilty of 1 count. And with that, thank you for your time.
Okay, thank you. Thank you to both counsel. Court will now be in recess for 15 minutes until 10:45.